The title of our first panel this morning is Speeding Ahead, Regulators and Litigators on the Class Action Accelerator. Since we seem to have a machine theme going on here, or maybe an automotive machine, I thought we could start out by talking about what regulations will be driving class action lawsuits. After that, we'll get out the map of the so-called class action highway and see what kind of potholes or roadblocks companies may be facing in litigating these cases. Let me introduce myself first. I'm Joan Gartlan, a former journalist and media consultant who specializes in legal issues. Our panelists are Eugene Scalia, a partner in the Washington office of Gibson, Dunn, and Crutcher. Gene is co-chair of the firm's administrative law and regulatory practice, and also co-chair of the firm's labor and employment practice group. Gene has extensive experience participating in matters before federal regulatory agencies and challenging agencies' actions in court. Ross Higman is a senior associate general counsel in the class action and commercial litigation section of the Wal-Mart store's legal department. Since 2002, Ross has managed Wal-Mart's defense of numerous class actions of various types, as well as supervising the company's role in a variety of commercial litigation matters, including shareholder suits and payments-related litigation. Gene, let's start with you. We are at the end of an administration. There is a lot of regulatory activity happening even as we speak. Can you give us an overview of what changes you're seeing in the regulatory area and what impact those changes may have, including in class action litigation?
Sure. And thanks for having me, and thanks for the Pink Floyd. You know, my doctor told me I couldn't have coffee this morning, so I was very pleased to be able to be here and get that, get the juices flowing with that. You know, the last few months of administration are always interesting from a regulatory perspective because you tend to see a lot of activity in those last months as the people that are headed out try to finalize their agenda and at times push through some things that are either particularly important to them from a political perspective or sometimes, especially after the election, finalize some things that are actually quite controversial and they didn't want to become points of dispute in the election, but they would like to get resolved before they head out. This administration's been particularly interesting from a regulatory perspective because of the difference in parties in control in the White House and the Congress. And since what I guess about 2013, the president's been quite frank about his frustration in working with Congress, his intent, therefore, to go ahead and move through regulation wherever possible instead. And so what we saw going back till then was a whole series of executive orders on a range of matters, but a lot of them in the employment area, and many of those actually having to do with arbitration. So you know, there are a lot of rules right now that are coming out that are controversial, that are already issued and challenged. Just yesterday in Texas, a federal court issued a preliminary injunction of the administration's so-called new blacklisting rule, which is really very important sweeping regulation that requires government contractors to report all of their labor and employment litigation adverse results, including even when the federal government just files a complaint against them. That has to be reported as an adverse result, even though the government has just made accusations, not won a suit. One of the provisions of that regulation was a prohibition on mandatory pre-dispute arbitration agreements with respect to sexual harassment claims. That was struck down as violating the Federal Arbitration Act, or I should say preliminary enjoined yesterday by the judge who said the government had a very low likelihood of succeeding on the merits. The CFPB, as many in the room know, has proposed a rule that would outlaw arbitration in consumer financial contracts in instances where there's a pending class action. This is another very controversial rule. The Chamber filed some really excellent comments opposing it. There are other restrictions this rule would put on arbitration agreements. And it reflects a really very general and deep-seated opposition to arbitration that we're seeing in some of these regulations coming out. Just one, I guess, two last I'll mention. Another suit was filed, I think again just last week, against an HHS regulation that also banned pre-dispute arbitration agreements, in this case, in the healthcare sector, between patients and residents at long care facilities and the folks that operate the facilities. And at one point, HHS determined, it said that, in conclusion, we believe that all arbitration agreements are basically unconscionable. So there you have it. We have on the one hand a federal law a federal policy favoring the arbitration of disputes, but on the other hand, a number of federal agencies right now that are making arbitration more difficult, and importantly, they're doing that in substantial part in order to make class actions easier to bring. The last rule of note, very controversial rule issued by the Labor Department earlier this year regarding who constitutes a fiduciary under ERISA and also with respect to IRAs. That also has a provision which I think is wholly outside the Labor Department's authority and I think violates the FAA, but that also has a provision saying that you can't require people to arbitrate disputes that would otherwise be subject to class action. So that's some of what we're seeing, Joan. A lot of really interesting regulatory activity. I think a lot of it that pushes beyond the bounds of what these agencies' statutory authority is, but a surprising amount also that is trying to get at arbitration and to favor class actions instead.
Well, just before we get to Ross, what kind of impact do you think that's going to have? I mean, you talked about increasing the number of class actions, but just how do you think that is going to play out in the next couple of years?
Well, first, let me confess I'm part of the litigation machine. Worse yet, I'm an occasional plaintiff's lawyer, as you mentioned in introducing me. So there will be lawsuits over a lot of these regulations. The fiduciary rule, the chamber has joined others in suing, and that's a case that I'm handling. The rule regarding arbitration agreements in nursing homes has also been subject to legal challenge. The blacklisting rule I mentioned, there's an injunction. And so I don't know that these rules will withstand scrutiny in the form they were adopted. I think it's quite possible. I think the better view is the courts will hold either that the Labor Department is not in the business of regulating arbitration agreements. That's not their job. It violates their authority. Or the courts will say, as the district court in Texas suggested, these kinds of measures are preempted by the Federal Arbitration Act. But if the rules do hold up in court, then certainly you will see a sharp reduction in arbitration and a rise in class actions. Obviously, the other really big wild card out there is the position advocated by the National Labor Relations Board that the National Labor Relations Act bars mandatory arbitration of potential class action disputes. That's now resulted in a circuit split. 3 cert petitions pending in the Supreme Court. That issue could get taken up this year. That's another really big item out there that, again, is the product really of the regulatory state through the NLRB influencing the class actions we might have. And if that NLRB position is successful, you'll definitely see more class action litigation where recently arbitrations had been the way that people were getting matters resolved.
Thanks. Now, Ross, you spend your time actually in the courtroom defending against class actions. There are ongoing efforts by the plaintiffs' bar to try to circumvent some of the protections against abuses in class action lawsuits from the Class Action Fairness Act. Can you give your perspective on what's happening in that respect?
Yes, thank you, Joan. I've been in those trenches for about 15 years, and that's since before the advent of CAFA. Of course, CAFA is designed to provide the protections of Federal Rule 23 to defendants and absent class members in large interstate class actions. And in my practice, in our practice, we invoke CAFA regularly. And I can give a short explanation of why. At the time that CAFA was being deliberated on in Congress, there was a rush to get class actions filed in state court. Wal-Mart had a bevy of wage and hour class actions filed against us. We had about 70 cases, one for each state, I believe. And of course, we're one of the largest employers in each state, or in most states, so generally they were fairly large cases that would meet the CAFA threshold. About half of those cases actually got filed before CAFA went into effect. And all of those were filed in state court. The other half were filed after CAFA went into effect, and all of those were either removed to federal court or originally filed in federal court. Of the cases that were filed in federal court, not a single one had a certified litigation class. On the other hand, of the cases filed in state court, a significant number had, by no means all, but a significant number had litigation classes certified. And as the cases played out, they were almost all settled, and Wal-Mart paid far, far more money to settle the cases that were in state court than in federal court. That's taught us a valuable lesson that we need to try to be in federal court when we can.
So it appears to be working, the Class Action Fairness Act appears to be working.
Yes.
in Wal-Mart's case, but you say there's now some attacks or ways, people working to get around the provisions of the Class Action Fairness Act.
That's correct. Among the stratagems to take advantage of gaps in CAFA are filing cases. Well, of course, the first one was to file cases before CAFA went into effect. We've covered, that window is closed now. Another is to file cases that are not class actions, that are representative actions and allow for significant recoveries, in particular recoveries of fees, but are not classified as class actions under the nomenclature in CAFA, so they're not removable. Another has arisen just recently, and it relates to the no injury class actions that Lisa was mentioning earlier. Perhaps I'll take a minute to just delve into that one, because what the Spokio case, which is the recent Supreme Court decision on no injury cases, triggered is a focus now on Article 3 standing. And in some states, of course, in state court, the requirements of Article 3 of the federal Constitution don't apply. So we now have cases in which plaintiffs are seeing their plaintiffs who are in cases in federal court are seeing their class certification motions denied, and we're seeing plaintiffs who are moving to dismiss their cases to try to get back to state court, because they know that they will not be subject to the standing argument there. They also know that the case will not be removable to federal court. In fact, there are rulings now from federal district court saying that the case is dismissed for lack of standing without prejudice to the plaintiff's ability to refile in state court. So there's an invitation going out there.
What are some of the arguments that they're trying to use to make it a state court case as opposed to get around the CAFA requirement?
An example is a recent case in the Northern District of Illinois. It was a class action under the Biometric Information Privacy Act, which is an Illinois state statute. The plaintiffs had alleged that the defendant, who was SmartCart, had taken their biometric information, a fingerprint, and had failed to disclose to them how long they were going to keep the information, and had failed to satisfy the requirements of the statute. They did not allege that they had been harmed in any way, that their identities had been stolen or that any other injury had occurred. And the district court granted Smart Cart's motion to dismiss for lack of standing. But meanwhile, the plaintiffs know, because of recent state court decisions in Illinois, that they can go and refile their lawsuit again in one of the Illinois state courts and not face removal and not face a requirement of standing. The same dynamic works under various consumer privacy statutes relating to credit card transactions. The Song-Beverly Act in California is a prime example, and Wal-Mart actually has a case under Song-Beverly, as does IKEA. And in IKEA's case, the district court denied class certification. The plaintiff appealed, but now the plaintiff has, in his own appeal, her own appeal, I believe, moved to dismiss for lack of jurisdiction so that the case can be refiled in state court. So that's the basic idea. They realize that there are jurisdictions where the requirements of Article 3 don't apply, and so they're trying to get out of federal court and get to those jurisdictions.
Looking forward a little bit, in case anybody doesn't know, we are in the midst of an election season. There are going to be a lot of changes, or maybe there will be a lot of change as a result of the election one way or the other. Gene, what do you see happening under either a Clinton or Trump administration as far on the regulatory side?
I think we'll continue to see fairly aggressive action on the agency regulatory front, because I think that regardless who's elected, we're likely to have close enough divisions in Congress that it will be very difficult to get major legislation through. So if you're the president, you've got an agenda, you've got supporters that you want to satisfy, and if you can't get it done through legislation, you look to agencies. And I think that's a lot what we've seen in the last 3 or 4 years arising out of President Obama's frustration with Congress. And I think we'll see more of that. To me, from a sort of legal perspective, it's fascinating, because what I see is agencies who are pushing farther and farther beyond what their intended statutory role was. You take the blacklisting rule, the federal procurement process was not supposed to be a powerful weapon for regulating the employment relationship. But that's what that blacklisting rule is about. Or you take the Labor Department fiduciary rule. The Labor Department was given zero enforcement or oversight authority with respect to IRAs. And yet it is using this very tiny sliver of authority it has to define who's a fiduciary under IRAs to build a regulatory program over IRAs that's at least as large as the program under ERISA for employer-sponsored plans. So these are really vast changes in policy, and they're being forced more and more through agencies that seem to me not to have been blessed with that kind of role by Congress. And I think we'll see more, and the big unknown, I think, is how the courts will respond.
Well, it is an unknown, but do you want to make a prediction? Do you think some of these are going to be, obviously be challenged in court? Any predictions on how they may fare?
Well, you know, always hard to predict.
You may be challenging some of those.
Right. I think the fiduciary rule is legally very vulnerable as a rule that goes well beyond the authority that Congress gave the Labor Department, again, opining on matters like the appropriateness of arbitration and establishing for IRAs a whole range of standards that Congress quite consciously did not put in place. I think that when Congress looks at an area and decides to regulate it in a particular way, it's not to the Department of Labor or any other agency to say, you know what, Congress didn't quite get it right, we've got a better idea. I think the FAA challenge to rules like the nursing rule that I mentioned, or to what the Labor Department has done also will, it's a very important legal argument. I don't think that the FAA intended that federal agencies would themselves defeat what is our national policy of favoring arbitration. But that will depend on the courts. And obviously the Supreme Court, when it comes to arbitration itself, has been at times closely divided, and I think we have to expect that will remain true.
Ross, we're almost out of time, but do you want to give any kind of prediction as to where you think the courts are going to go, the federal courts, in or circumventing some of the circumvention, I guess, by the plaintiffs' attorneys?
I really don't see a judicial patch for any of these gaps in CAFA that we're seeing. I think the courts, for example, are applying principles of comity in occasional cases to refuse to exercise CAFA jurisdiction. I think the Article 3 issue is, I don't know of a judicial solution to that. So I think it's something we're going to have to deal with.
Thank you both very much. We're out of time, but thank you. It was very interesting and insightful discussion. Appreciate it.
Thank you, Joan.